I know this is going to be recorded. Westborough TV is going to do a recording of it. So if you have folks that weren't able to make it tonight, particularly if you have staff that take minutes that were unable to make it, we'll have that recording available for people to watch later. So we have Brian Riley here from KP Law, and he's going to give us an overview, of the open meeting law and public records law, and this is really your opportunity to ask all the questions that you have. So, thanks.
All right. Thank you. It's nice to be here. Thanks for coming out. I know it's a gorgeous evening, so we'll try not to make this any longer than necessary. But I've given a lot of these, seminars, trainings over the years, and then the past few years it kind of slowed down because we couldn't meet like this. So it's nice to have them pick up again a little bit. So I'm going to go over, most of this presentation is on the open meeting law. It's got a lot more detail and kind of nuances, but we'll talk about public records towards the end as well. And yeah, if anybody does have a question, just put your hand up and I'll do my best on it. So because we're lawyers, we have to have a disclaimer. But I will say that I'm kind of going over the general aspects of these laws, how the Attorney General interprets the open meeting law in particular. But what the answer is does really depend on the facts. So, there may be some things which come out a little differently than I describe here. But hopefully this will at least get you started. So these are sunshine laws. Pretty much every state has them to enable the general public to see what's happening at their local government. There is a third one, the conflict of interest law, but trying to do all three at once is really an awful lot. So we're doing these two tonight. So starting with the open meeting law, we'll cover what kinds of meetings are subject to the law. For example, town meeting is not subject to the open meeting law, no aspect of it. And there are a bunch of rules. This is not created to make government more efficient, that's for sure, but it is created to help the public be able to, learn what people are doing. And what are some common violations, how to avoid them. So there are lots of requirements. An important one is notice. Anytime a board that is subject to the law, which is pretty much all boards in town, they're required to come up with an agenda of what they're going to do at their meeting and get it posted at least 48 weekday hours. You don't count weekends or legal holidays. And part of getting that notice in there is filing it with the town clerk's office. And I believe the clerk's office pretty much gets it on the calendar on the website, which is your official posting site. You might put it on a bulletin board or something as well, but it's important that it get on the website in a timely manner. And meetings, it depends, it's important what your location is, that it's accessible. The state Commission on Disabilities really handles the Americans with Disabilities Act requirements, but it's important that people are able to get to the meeting. I will talk a little bit about remote meetings too. And the notice should have some detail as to the subject matters that are going to come up. So people can look at the agenda and say, oh, I'm interested in that, I guess I'm going to go. And what the nature of the meeting is, most meetings are all an open session, so people can either sit in the audience or if it's being broadcast on local cable or something along those lines, the public can see. There are closed sessions or executive sessions. I'll hit on some of the primary things where a board's allowed to meet behind closed doors. How meetings are conducted. A board meeting versus a board public hearing are somewhat different. Certain parties have more rights to speak at a public hearing. But in general, the chair of the board is going to control who gets to speak and when. As I say, we'll talk a bit about remote and hybrid meetings in a bit. And then it's very important because people file complaints about minutes all the time. For every meeting, open or executive, you have to have someone keeping minutes, and they don't have to have everything that everyone said, but there needs to be a good detailed summary And the Attorney General looks at it as somebody who wasn't at the meeting could look at these minutes 6 months or a year later and get a general idea of what was talked about, what decisions were made. The Attorney General has some regulations that say unless there's kind of extenuating circumstances, minutes should be approved by the board within the next 3 meetings or 30 days, whichever is later. And there is some exceptions or different ways where a board can approve their meetings. Sometimes you can even have the chair approve it. Let's see. So nearly all meetings. So I'll mention emergency meetings a little later, but those are definitely the exception. And the statute says that the meeting notice, the agenda, has to have all the topics the chair anticipates will be discussed with enough specificity so that the public knows, what's coming up. The chair anticipating is kind of an important distinction because if something gets brought to the chair's attention the afternoon of a meeting, obviously you're well within 48 hours. Can the board talk about it? If the chair didn't know it was coming, you can. It's not a violation. The Attorney General's office says, we recommend that unless it's something which would really benefit from a immediate discussion, you put it off till the next meeting, so you can put it on your agenda, but it's not a violation if it's something minor or something that board can at least start to talk about. And the definition of meeting in the open meeting law is that when there's a quorum of a public body, which typically is a majority, discussing matters within its jurisdiction, that is a meeting, and that means if a quorum of a board is doing that not at a posted meeting, that's a violation. So you have to watch for that. And the other way that quorums can often accidentally be found to be holding a meeting is through email, which is very convenient. Everybody's using it. But if an email is going around between board members and now you've got a majority, 3 out of 5, 4 out of 7, seeing what everyone is saying, seeing what their opinions are on something that's before the board, all of a sudden you've got a violation that has to be dealt with in some fashion. So be careful of email. So these are some of the definitions. Meeting is a deliberation amongst a quorum of a public body discussing matters within the jurisdiction. So if you're talking about something completely unrelated to your board and there's a quorum of you there, that's not a violation. Somebody may see this happening and think it's a violation, but you do have to watch, what the discussion is. Deliberation is any kind of communication, including email, where a quorum is involved on any public business. Quorum, as I say, typically it's a majority. Occasionally there's some exceptions like special permits for a zoning board require 4 out of 5 votes if it's a 5-member board. And so if there's 3, that's actually not a quorum for that particular hearing. But most of the time it's a simple majority. And then public body, any multi-member board, committee within a town, however created, elected, appointed, otherwise constituted, established to serve a public purpose. So it does apply to more than just boards that are created by statute or a board that's created by a bylaw, like an open space committee. You don't really find that in the general laws. But if you have a bylaw, they're certainly going to be covered by the open meeting law. And then you have kind of temporary committees that are put together, appointed to go out and do something and come back and report. Those are also considered public bodies. And I kind of put stars next to subcommittees because I wanted to mention that specifically in the definition, a subcommittee which is established to make a recommendation to another public body is also considered a public body. And so if it falls within that as a subcommittee, they are also required to post their meetings and take minutes and everything else. Now I will just mention that the Attorney General's office gets actually complaints come to your board first, but eventually if someone doesn't like the answer, they go to the Attorney General's office. And it's not uncommon for someone to say, this is a subcommittee and they were meeting behind closed doors, and that's a violation. Well, it depends on the facts. And I'm just reading from one of the Attorney General's decisions saying, in reviewing whether a public body created a subcommittee, our analysis hinges on the public body's action and whether it intended to create a multiple member body. The gathering of individuals on their own initiative does not create a subcommittee. And this particular one was where a board designated one member out of 5 to do something, and then before the next meeting, a second member called up the first one and said, hey, I'll help out. And well, they said, okay. And so then that was 2 of them. But it was not, they were not designated by the board as a subcommittee to go out and do this. It just kind of happened organically. So that was, in fact, not found to be a subcommittee. Another example, a town manager might have a monthly meeting of all department heads. Everybody there is a public official, but it's not a group that has power to do something as a group. They're all individuals, and so that's also not considered a public body. Meetings, as I say, are pretty much any time a quorum is there, it's considered a meeting, but these are specifically excluded. A board, usually the chair, can send around, again, email, most common, can send around an agenda, can ask questions about board members, about scheduling, we're not going to have a quorum on Monday, can people make it on Wednesday? Even though that's going to all the members, that's not considered a violation. And circulating some kind of reports or documents is also not a violation. But always important on these things is not to express an opinion on it. So if the chair is given a report from a consultant that's working for the board, can send it around saying, here's so-and-so's consultant report, we're going to talk about it at our next meeting, period. That's fine. If it goes on to say, pay particular attention to page 5 because I think this is incorrect, all of a sudden that's an opinion, and if it goes to everybody, you've tripped a violation. Attending an on-site inspection, out in the field, particularly things like Conservation Commission, Board of Health, that sort of thing. That's also not considered a meeting, but the board should not kind of huddle off and talk about something which should be held for a meeting. Attendance at a public or private event, even this tonight, if you had a quorum of a board here, you're sitting here, we're talking about this law, you're not doing board business, so that's not considered a meeting. And also, if one board is holding a hearing, for example, and other boards might have to deal with the same thing down the road, the whole board may want to go sit in the audience. That is also fine, as long as they don't sit together and start deliberating with each other. Tips to stay out of trouble. I think I've talked about some of these already. Just don't make it look, if you're not holding a meeting, don't make it look like you are. Doesn't mean you can't be in the same room, but Jay, I'll just be sure that it doesn't look like maybe you're talking board business when you shouldn't be. It's fine though for one board member in the audience to get up at another board's thing and express their opinion on something, that's fine. We certainly everybody has their rights to speak as an individual. But you might, depending on the matter, especially if it's controversial, you might want to get up and say, I am on the Board of Health, but I'm just speaking as a resident. It's not a bad idea. Sometimes if there are 2 boards with an interest, they might decide, well, maybe a joint meeting is really the way to go. So we can all talk with each other on the record. The audience can listen or participate. In that case, each board should post a meeting 48 hours ahead and take minutes, et cetera. So email, again, it's a great thing, but you have to be careful not to start exchanging opinions. And so be careful when you hit reply all, when maybe you should only reply one. Keep it to, try to keep it to these things that are exceptions like scheduling or distributing, a report which is going to be held for the actual meeting. Assume the email might end up somewhere you don't want it to. I've certainly had emails of mine show up in the local newspaper, and maybe that's happened to you as well. And then, don't express opinions. Another thing to remember, although this is kind of more of a public record issue, is if you're on a board or in an office that's working with a board, and you're using the town email server, town email address, that's always a good idea to only use that to do town business in case somebody asks for copies of it. Because if you're talking about town business on email, on your own Gmail account or something, the supervisor of records says, well, that's a public record if it's public business. So you need to keep an eye on that. I think pretty much people here who have an official position have the Westborough site, right? Okay. Social media, another danger. Just like with email, how it can get circulated around and all of a sudden you've got a quorum involved. Facebook, Twitter, Instagram, all those sorts of things. A board member might post something, then another board member comments on it. If they're just talking about, personal business or posting family pictures or something, that's not a big deal. But if they're talking about something which is pending before their board and saying, this is an important town issue, I hope people come to our next meeting, and now another member chimes in and says something, again, you get to a quorum doing that, it's a problem. So be careful of that. Also, if you're talking about things which the applicant really should have a right to weigh in as well, that's just another reason to hold all that kind of comment for the public hearing. The 48 hours, as I say, doesn't include Saturdays, Sundays, legal holidays, so it's important to get it into the clerk's office in sufficient time to get it posted. In the old days, the billboard, the bulletin board outside Town Hall was everybody's official place. Now most people use the calendar webpage on your website, which is the case here. The notice has to include the date, the time, and the place that the meeting is going to happen. List the topics the chair anticipates will come up, as I say, and with enough specificity so people know what it is. There are also lots of complaints that get filed about agenda items that don't tell people enough, so they can't really tell what's going on. To say the AG's office has interpreted these as saying, a public can read the topic and really understand it. If it just says road projects, that doesn't say a whole lot. It's better than nothing, I guess. But if the discussion is really going to be about, the Central Street sidewalk project, well, that should be in the agenda item, so people really understand what's going to be talked about, what decisions might be made. And it really depends on what the subject is as to what's enough detail. But you should always think about, how the public is going to interpret this when you're putting these together. So the clerk's office gets them. That is the same slide. Sorry about that. So yes, unlike town meeting, which can go till 10 o'clock or whatever and adjourn to the next night, that doesn't work for a board that's subject to the open meeting law. If you think you might want to do 2 nights in a row because it's a big project, big presentation, you're going to have to post both nights 48 hours ahead, so you have to plan ahead. And it also doesn't substitute for other notice requirements. Again, I'll use let's say the planning board is going to talk about a zoning bylaw. They're also required to put something in the newspaper about that. So if there's multiple notice requirements or something might have to get sent to abutters, have to be careful on all of those, including the 48 hours for the meeting. Okay, so it's the town website. Yeah, avoid acronyms. The Attorney General has lots of things on that. Your board, let's say Conservation Commission is talking about something, and there's a variety of acronyms which apply to wetlands laws, and notice of applicability, NOA. Now, most people at home don't know what that means. And so unless they understand what's actually going to be talked about, what the address is, acronyms can be, can pose a problem. And so the AG advises against them. Same with abbreviations. Each of the agendas must, in some fashion, indicate the time and date that it was posted. A lot of times here, I believe the town clerk will put a date and time stamp on it, and then that copy is what ends up on the website. That's good. If it gets revised in the meantime, and it is okay if something arrives 24 hours before the meeting, you can revise your agenda and add that on there as soon as you can. But both the original and the revised one should be right there so people can see that it's been changed and when the new one was posted, when both of them were posted, actually. This was something which arose early when the Attorney General's Division of Open Government that oversees this came up because they want to see as much detail as you can so people know what's going on. They said, don't use these, kind of placeholder things that are old, that in the old times was fine. New business, old business, superintendent report. So obviously new business and old business, if that's all it says, that really doesn't tell the public anything. And it's not quite as stern perhaps as this says, but if it's the DPW superintendent making a report, if the superintendent has kind of advised the chair, well, here's the 3 things that I'm definitely going to bring up, it'd be a good idea to have a bullet point on those 3 things. It doesn't mean if the superintendent then comes up with something else that day and wants to bring it up that that's a violation. But again, this all goes back to give the public information so they understand what's going to go on. Oh, sure.
So if, let's say, agenda,
Right.
and the report is going over the report of the so sort of placeholders.
Yeah.
If there's documentation of what it's about.
Yeah, I think that's fine. Maybe, a lot of boards will post sort of a packet of the documents they're going to use, that kind of thing. So, it may be that people are used to looking there. I think just to be safe, again, if there's a couple of things that the health inspector is going to talk about, it still wouldn't hurt to have or maybe say, C board packet, attached or something like that, so people know where to look.
Question. I'm the library trustee. In our meetings, we usually have trustee issues. Minor stuff, we're congratulating the trustee on the
Right.
birthday. Is that kind of thing okay?
I'd say it is, particularly if it's not something that, the public's going to think, well, if I knew they were talking about that, I would have showed up. Plus, again, that's why I'm reluctant to say, you can never have town manager report with nothing after it, because it may be that the town manager, the DPW superintendent is putting together something and just doesn't talk to the chair, doesn't let them know what's going to be talked about. Or maybe it's all new stuff that just came in over the weekend. That's really kind of the bottom line is, did the chair know this particular thing was going to come up? And if not, to me, there hasn't been a violation. So, but I think that's an example, as long as it's not something which people would look back later and saying, oh my goodness, how come we didn't know about that? Yeah, there certainly are people out there keeping an eye on these things, and they're not shy about filing complaints. As Christy know, we dealt with a couple of them last week from someone who used to live in southeastern Mass, now lives in Alabama, And yet, he still files complaints against boards in Massachusetts, so you just never know who's out watching these things. He's a frequent flyer in our office. So emergencies, the law does say that if it's an emergency, you can get past the 48 hours. You know, it's like all of a sudden the weather forecast has changed and we're going to, instead of 2 inches of snow, we're going to get 28. The select board might want to meet with the DPW superintendent and say, you know, what are we going to do? How many police officers, details we're going to need? You know, certainly something like that is a valid emergency. But the AG is very narrow interpretation of that. They do tend to say natural disasters are public safety issues and not much beyond that. If you forgot to put something on your agenda or forgot to deal with something and all of a sudden a deadline's coming, they're not going to look kindly on that as justifying an emergency. And in general, the advice, if you do happen to feel you have a justified emergency to deal with, what the AG recommends, what we recommend is comply the best you can. You know, if you're going to hold a meeting and 18 hours later, well, post that you're going to do that. Only talk about the things that are an emergency, of course. Don't start dealing with normal business. Take minutes, just like you would in a normal meeting. And then at your next regular meeting, you can say, you know, just for the record, we held this emergency meeting because, and we're going to approve minutes for it and attach it to the minutes of this meeting. That way, at least people can feel like, okay, you know, that was a legitimate reason, and we can still see what happened, even though we didn't get the full 48 hours notice. Yes? Oh, yeah, that can happen. You may have a meeting scheduled in town hall, and all of a sudden there's a storm and power's out, so you don't want to use the building. I guess, I mean, depends on the circumstances. You know, give the public as much notice as you can. Maybe put a notice on the front door of the building or so. It's not a violation of the open meeting law, however, to schedule a meeting and then cancel it even last minute. That is not a violation. But yeah, I think that's the best you can do, is just try to let people know it's not happening if you can. Yeah, if, I mean, for most public hearings, most matters that legally require a public hearing, you can get an extension. You know, you talk to the applicant or their attorney and say, you know, this happened. You know, what can we do? That may sort of depend, because if what happens is the public hearing is going to go forward and the applicant can't make it or their attorney can't make it, you know, we usually advise, well, open the hearing and then continue it. That way you don't have to go back and do the newspaper thing all over again. If it's because there's no power in the building, you might not be able to do that. So it kind of depends. You might actually have to start all over again. Okay. So yes, as you know, particularly if you're on a board or work with a board, everything changed in the spring of 2020, and so you know, boards were you know, suddenly authorized to meet completely remotely. Zoom took off, and in general, before, what the law said was, you know, you have to have either you have to have your quorum in the room, or under some circumstances, you can have a member participating remotely as long as a quorum is in the room. But all that changed. And so, you know, hybrid meetings and remote meetings are still authorized. It varies widely across the state now. A lot of boards are saying, well, we want to do everything in person, and that's fine. But the fully remote or the hybrid, with people being able to come in through Zoom, and yet you've got the board sitting in the room, all that kind of thing, is still okay. We thought maybe the legislature would try to make some permanent changes this spring. They decided to kick it off for a couple of years. So this current status is around for another 2 years. So instead of holding a meeting in public, the board can arrange for, quote, adequate alternative means, and that is through Zoom, or if possible, you could have your board being televised live on local cable access. That's also acceptable alternative. Obviously, people can't participate in it if they're just watching it on TV, but that's still valid access. But as I say, it varies a lot. You certainly can have all in person, you can have all remote, or you can have a mix, the hybrid meeting. So the alternative access means people must be able to watch and listen at a minimum live. You can have a 20-second delay if it's some kind of broadcast that would do that. If a technical problem arrives during that, your board is supposed to kind of suspend what you're doing, see if it can be fixed. If it looks like it's going to be multiple hours to get fixed, you may just need to end the meeting and take it up on another date. The AG has been very clear that recording your meeting, not having it accessible and recording it and then posting it the next day, for example, does not, that's still considered a violation. People could still see it, but it wasn't live. And as I say, Zoom or similar things, Teams meetings are usually they work pretty well and they're free, so it's kind of a good solution to that. Oh, yes.
What about a hybrid meeting? If the
Well, let's say it's hybrid in that, let's say the board is there, they've invited the applicants in for a public hearing because they don't want to do that face-to-face, but say, for health reasons or whatever, everybody else is going to have to be on Zoom. If the Zoom crashes, and you can't get it going again, you're going to have to stop the meeting.
right, what if the case is that option to attend in person?
Yeah, well, then it probably, it'll depend a little bit on the facts, but I think if if your meeting notice said you can either be in person or on Zoom, and the Zoom goes down, my recommendation would be to stop and take it up again. If you can, if you're planning to do it all in person, then it's really not an issue. If something goes down, but it was advertised as an in-person meeting, you're not required to have this alternative access, okay? The law says, and it still applies, that if the chair knows that this meeting is being recorded, the chair is supposed to make a statement. And that applies both to, let's say you're having a fully remote meeting. Obviously, you can tell right on the screen that it's being recorded. The AG wants the chair to announce it. But in the pre-COVID days, that would also apply if it's being recorded for cable TV. Make a statement so everybody in the audience understands that it's being recorded. Or if someone in the audience says, I'm going to take a video of this. Which is legal. The chair is also supposed to announce so anybody who's in the room, participating is aware that this is happening. Yes.
Sorry.
Hmm? Well, no, it's really that for the most part, you're not supposed to record people without their knowledge. That's kind of the general. It's not just wiretaps like your phone. It's more sort of, you're not supposed to make a recording of someone without their knowledge. There's some nuances to that too, but so that's the idea here. Anybody who's participating or in the audience understands they're being recorded. That way, if they get embarrassed later, at least they were warned. All right. If you're having an executive session, all the votes have to be like roll call. That is also the case if you're having a remote or a hybrid meeting. So anytime the board votes on something, they need to do a roll call and have it recorded in the minutes that way. It should be announced at the beginning that even if, again, even if it is a fully Zoom meeting, the chair is supposed to announce, who's participating from the board and that they're all remote. Seems kind of silly, but, and let's see, cameras. Oh, yeah, this is also in the law, the pre-COVID law as well. If there's a member or even all members who are having an executive session and it's either remote or hybrid, so at least one member is participating, on camera, they are supposed to state for the record and have it in the minutes that either they're alone or they're not with anybody who would compromise, the confidentiality of the meeting. These are hybrid. So there are a lot of variations. A board might want to all sit in the room, but then have everybody else on Zoom to observe. That's fine. As I mentioned, the board could invite certain parties, like the ones who were there for a public hearing, to come in and join them and have everybody else on Zoom. That's also fine. As long as, at least for the open session part, the public has to be able to hear. They don't necessarily have to be allowed to participate, but they have to at least be able to see and hear what's happening. And as I mentioned, if it's a fully in-person meeting and was posted that way, you don't have to have Zoom or cable TV. If it is fully in person, however, just like before, you need to have room for everybody who's there. Let's say you're having a meeting in here, but it's some really controversial issue and 200 people show up. You're probably not going to be able to fit them in here. And so what the advice is to adjourn and figure out where you can put 200, 250 people and renotice the meeting. The AG has said that it's okay to have meetings in a location and require a mask. You're seeing less of that these days, of course, but they will still recognize that. Oh, yeah.
So we're currently doing these hybrid meetings, but basically the whole board is there, and sometimes maybe one or two are remote. We're not using this thing where the majority might not be there. Post an in-person meeting, and then do you have to do anything about having a remote?
You mean a remote board member?
Yes.
Yeah. No, if you're having it in person, because again, pre-COVID, the law itself says board members can participate remotely if the Attorney General adopts regulations, and the AG did. And so you don't have to put it on the agenda that that's going to be the case, but if it is the case, when you start up, the chair should say, these three members are here, we have one member participating remotely. We're going to put that on the record. You in the audience will be able to hear him, he'll be able to hear you. But no, it doesn't have to be posted ahead of time. Kind of mentioned some of this before. The chair in general is kind of inferred to control what the agenda is. And things that are reasonably anticipated should be on the agenda and posted in a timely manner. And if something gets added later, try to update it as soon as you can. Matters not reasonably anticipated, as I say, the Attorney General has said this is not a violation if the chair didn't know this was going to come up. So you can talk about it, and that's okay. But particularly if it's kind of important or controversial, we strongly recommend that you put it off till the next meeting. So that's the basic advice. Put on there. I think you mean as a board member. Yeah, I think that is, I think the Attorney General does say that's the case. Not for the public who might be listening, yeah. Thanks.
One more
Yeah.
in-person question. When you have in-person and at a board member or somebody could be, what about a guest?
Yeah, that's fine too. Let's say the board is posting it as in person. It's kind of an interesting twist on that because before the law and these regulations only addressed if you're having a board member who's remote, how to do it, the steps you have to take. It doesn't say anything about allowing outsiders to participate. It's not required that you allow that, but if you do, somebody who has something to add to a hearing or a matter before you, I think that's fine. I'm sure the AG would say, as long as the audience can hear it too. Yeah, there's nothing wrong with that. Conducting the meeting. This one leads to some controversy. But, if it's a regular meeting, you may have a room full of people. People might want to speak, but what it says is that no one gets to speak at a board meeting, unless recognized by the chair to do so. Some chairs, and it depends on what the topic might be, they like to hear from everybody and encourage people to come and speak their mind. But it's not mandatory. And a board can decide, well, we'll have a public speak section for the first 10 minutes of a meeting. And anybody who has anything they want to say, we'll let you talk. And, usually it's a good idea not to get into a discussion with that, but, or some boards do it at the end, same kind of thing. Yeah, I'm gonna mention a court case in a little bit where if you do say, okay, this is open to the public, anybody who wants to speak, and somebody gets up and starts saying something you don't want to hear, you're kind of asking for trouble if you try to shut down the public comment period. But I'll get to that in a minute. As I say, it's kind of a policy for the board, how to do it, how long, you're going to give somebody 2 minutes to talk about what they want to. You're going to let them speak more than once. Again, it's best not to kind of open it up to a debate that you didn't know was coming. So yeah, you have to kind of schedule that if you're going to do it without thinking about what topic they might bring up. Let's see. So yeah, as I say, try not to get into a debate with someone. You can just make note and say, okay, thanks for bringing that up. Maybe we'll put it on a future agenda. Yeah, there's nothing wrong with not continuing a conversation that somebody brought up. And let's see, yep, all right. Yeah.
Question about the public comment. We've had, you probably know, some controversy, the library attorney, some controversy. And they actually were very frustrated by this. Not engaging, but there's a few individual radio members who often met with himself.
Oh, yeah.
So that we can have,
Yeah, that sounds like a very reasonable approach. There's certainly no open meeting law violation there, and I would say if one member is doing that, well, for one thing, there's no such thing as a one-member subcommittee, but it doesn't sound like that's really what they're doing anyway. And so if then that member comes back and said, somebody brought up this, and I think our board should talk about this in the future. Yeah, that's perfectly fine.
we actually thought about forming a subcommittee.
Yeah, okay. In that case, I think the chair should say, please, we're trying to restrict this to matters that are within the jurisdiction of the Council on Aging. If you've got something that's a select board matter, you should take it to that, take it to them. Yeah, yeah. Well, I'll just say it now. I'm going to get to this case, which involved the Natick School Committee. That's where I live. And they opened it up for this public speak period, and somebody got up and started really going after certain staff people at the school and, saying nasty things and saying they're corrupt and whatnot. And the chair shut them down, and sure enough, got taken to court, and the court said, you can't do that. You can't let one person get up and say something about the schools, and then the next one says stuff you don't like, you can't shut them off for that. That's First Amendment stuff. So it gets complicated. But I think that's a good approach. It's just, look, we can't do anything about that. You should take it to the board who can. Nothing wrong with that. Recording, we've sort of touched on already. If there's going to be any kind of recording, the board's recording it, it's on Zoom, cable TV is recording it, or someone in the audience says they want to. The chair is when the chair is aware of it, is supposed to make an announcement. It's just so everybody's aware and, knows whatever they say is going to be captured. The chair can, particularly if it's in the room, the chair may regulate how it's recorded. You don't have to let them set up a big camera right in your face. But you can't tell them they can't do it at all. Yep. The supervisor of records, since I've been at this, which is a long time now, they still say you have to have written permanent minutes. So, yeah, maybe someday, with technology that would, where somebody could go and watch the thing. But no, you still have to use the recording and make written minutes. Yeah.
If you have an open meeting and you're doing it by Zoom also, does it have to be recorded?
Does it have,
Have a meeting in a conference room and
Yeah.
you're doing it Zoom because a couple people couldn't make it in person, does it have to be recorded?
No, it doesn't have to be recorded. You could be taking regular minutes to create written minutes, and the minutes would say member X and Y were participated remotely over, a conference call or something. But no, it doesn't mean you have to record. Even a regular meeting, you don't have to record it. You just have to have some way to make minutes afterwards. Executive sessions, as I say, these are the exceptions to the rule that where the public has to be able to come and listen and watch. If you're going to have an executive session, which means keeping the public out, you're supposed to announce what the subject is. There's 10 things in the statute which are valid purposes for executive session, and that's it. You're supposed to give the public an idea of what the executive session is about, but not with saying so much that you're kind of compromising the whole point of having it private in the first place. The board has to open in an open session. They have to vote to go into executive session. That gets recorded as a roll call. Any vote during the executive session gets recorded as a roll call. And also before you go in, the board should say whether you're going to come out into open session again or whether you're going to finish that and adjourn for the night so people aren't waiting around. And yes, only discuss matters cited. It's real. I've been in plenty of meetings where we went in to talk about this one court case, and pretty soon board members start straying into other stuff, and you have to kind of rein them in because it really has to be limited to that. As I said, there are 10 different ones. A couple of them are pretty esoteric and don't come up that much. The most common ones are purpose 1, which is you're going to talk about the reputation, character, or health of an individual. So not professional competence. If you're doing an annual review of an employee, that's not supposed to happen in executive session. But you get a complaint filed against someone who's working under your board, you can bring them in and talk about it. That's valid, executive session. You have to give 48 hours notice to the individual you're going to talk about, whether it's an employee or someone else, so they have the opportunity to come participate, defend themselves, so to speak. Purpose 2 is conducting strategy sessions for either collective bargaining or that's 3. Strategy sessions to prepare to negotiate with non-union personnel. So the board wants to renegotiate a contract with an employee. They can come in and talk about what their approach is going to be, what changes they think should be made. They can do that privately. They can also actually conduct collective bargaining or contract negotiations with a non-union personnel in executive session. You generally have to, when it's all done, kind of make those minutes available and disclose what the contract is. Collective bargaining strategy or litigation strategy. So people in my office often meet with boards to say, well, this case is going on. We just got hit with a motion for summary judgment. Here's how we think our response could be, one or the other, so the board needs to give us some direction. That's all valid purpose. The chair is supposed to declare in open session that's what we're going into to do, to either just strategize for collective bargaining and which union, or litigation strategy for Smith versus Planning Board. You're not giving anything away then, but the AG says the public has a right to know what, that these things are advancing. Let's see. Oh, similarly, if you're going to talk about purchasing or the value of real property, which you might want to buy or sell, you can do that in executive session. Obviously, if you have that in open right from the beginning, you're kind of losing your bargaining power. Again, the chair is supposed to declare that that's what you're doing. If this is a piece of property that no one even knows for sale yet, maybe someone has just offered it to the town for a limited time, you don't need to put the address of it. But once it's become sort of an ongoing negotiation, the AG has said, well, then you need to consider the purchase of real estate, Ray 15 Cooper Street. Search committees, that's purpose 8. There's kind of a special rule for that. If a board has appointed a search committee to fill a hired position, that board can meet, kind of get their notes together, how they're gonna do this. And then once they start getting in resumes and conducting interviews, they can do all that in executive session. And it only gets out to the public when they've narrowed it down to 2 or 3 or 4 finalists. And at that point, the hiring board interviews them in open session. But this is a good thing to have because you increase the number of people who might be willing to apply for this position if they think, well, if I'm not a finalist, I don't want my name getting out there that I was interested. And this allows the search committee to keep that stuff, even after it's done, that is not public. Let's see. As I say, ideally, again, if something comes up at the last minute, can you have an executive session to talk about something that just happened in a court case? Yes, you can. But ideally, you're going to talk about it 48 hours ahead. It should be listed on the agenda, just like everything else. There's only a couple of them that say the chair has to declare that it's going to compromise our position if we do this in open, and those state right in it. Minutes, again, big issue. So open session minutes have to be kept, put into final form, adopted by the board. Regulations say within the next 3 meetings or 30 days, whichever is later. If you need more time, you can, but if you get a complaint saying it's been 45 days and they've held 4 meetings and they didn't approve these minutes, we see a lot of complaints like that. And that's going to be held to be a violation unless you have some kind of good reason, like, well, our recording secretary quit after the meeting and took us by surprise, so we had to hire somebody else. But in general, those are the limitations. And there's a particular one for meeting minutes that if somebody makes a request, like a records request, They're supposed to be made available within 10 days, and that's not even business days, that's 10 days. If they're executive session, you might be able to say, this is ongoing litigation, so we're entitled to keep those private. Also, draft minutes are also a public record. You can keep that in mind. You may have had a meeting one night, somebody was taking minutes by hand to turn into typewritten minutes down the road. But if somebody makes a request right away, I want a copy of the draft minutes, that's a valid records request. Meeting minutes, if you've been on a board for a while, you're familiar with all this stuff. Date, time, place of meeting, which members were present or absent. A detailed summary of the discussion. Again, you don't need like a transcript, but you also don't want to have a half-hour discussion boiled down to one sentence, because nobody looking at that later is going to know what the discussion was about. Any decisions made or votes taken. Boards that are subject to the open meeting law can never have a secret ballot. And the minutes also have to include a list of any documents or exhibits that the board used during the meeting. So again, sort of bullet points, applications for a special permit, consultant report from engineer, all that sort of thing needs to be in a list so somebody can look at it later and say, oh, I'd like to look at that engineering report.
That point, document is physically present. About Zoom meetings.
That's a fair question. This again was pre-COVID where the AG came up with, well, it definitely has to be in the list if the document was physically present at the meeting. It was discussed and the content of it was discussed, then it absolutely has to be included in the minutes. Yeah, in a Zoom meeting, it's kind of metaphysically wasn't there, right? I mean, my advice would just be if the board started talking about some report they got and they're talking about, what it says, what we think is, the most important parts of it, then it clearly has to be listed. Okay. Executive session, again, you might have a court case that goes on for a year and a half, happens all the time. All your executive sessions for that can be kept confidential even if somebody asks for it. However, in general, boards should also try to keep to the 3 meetings or 30 days, whichever is later, to approve them. You can go into executive session just to approve minutes and not release them. But if someone makes a request, you don't want to have to admit that we've got 15 months of executive session minutes that we haven't approved yet. A board can authorize the chair, for example, to review minutes and kind of keep an eye on, this case was settled 3 months ago. We need to finalize these and either release them or decide which parts we want to withhold because they have attorney-client privilege or something. And those can, as I say, these can be reviewed in executive session. That falls under exemption 7, which is any other law which allows you to, to meet privately. Another example of that is Board of Assessors. They are supposed to keep any applications for abatement or a tax exemption private. So obviously, if they talk about them in detail in an open session, they've just violated that privacy. So Board of Assessors are allowed to meet in executive session to handle those things. Again, if somebody makes a request, you have 10 days to either turn them over if appropriate, or tell them, you're not getting this part because whatever the exception might be. Enforcement, everyone's least favorite part. So the Attorney General has this complaint form on their website. They say that unless it's on that complaint form, you don't have to deal with it. But most people who watch these things are aware of this form by now. They have to, so the person has to sign it. You're not obligated to respond to an anonymous complaint. But if you get one of these complaints, you have 14 business days to talk about it at a meeting. You can get an extension from the Attorney General's office if need be, but it's almost 3 weeks. And so the board needs to have it on their meeting notice that they're going to talk about this open meeting law complaint from Joe Smith. At your meeting, acknowledge that you got it, talk about, at least in general terms, what the allegation is, and talk about what you're going to do about it. maybe you want your written response to say, no, this was not a violation because, or if it turns out they said, well, your meeting was only posted 36 hours before, you might look back and say, oh, yeah, that was an oversight. That actually happened. So then you might want to do something like, for that meeting, we're going to go, at our next meeting, we're going to summarize all the discussions that we had and kind of ratify all the votes we took. The AG likes to see kind of curative actions like that. There has to be a written response either within 14 business days, however, or if you get an extension. Yeah. You don't have to. You could if yeah, you can if you want, but I write this Division of Open Government all the time and say, the board just got this. The next meeting is in 2 days and we're not going to be ready to deal with this, and then it's going to be a month. So can we get an extension until the day after the meeting in a month? And as long as they don't like to get requests when you've already blown past the deadline, but they'll always approve it if you give them a reason like that. Yeah, as I mentioned, if something indeed, you missed a detail and it was technically a violation, they like to see that you talk about it and promise to sin no more going forward. That's an acceptable, way to address a violation. They like to see kind of proactive, if indeed it's something that you needed to cure. So the written complaint, it needs to be filed within 30 days of the alleged violation. So if let's say, you only posted it 36 hours before, but if it happened 2 months ago, if you get this complaint in, it's a valid response to say, we got this, but we're not required to give any kind of detailed answer to something that was more than 30 days after. So, that's acceptable, and the Attorney General would follow that as well. If a complaint can be filed with the Attorney General's office, they get your response, they don't like it, they don't think it's correct. If it's between 30 days from when they filed the complaint and 90 days, they can file with the Division of Open Government and say, I filed this complaint, I'm not satisfied, I want you guys to look at it. And they issue these all the time. No, we don't find this was a violation. Yes, we do, but they've already kind of taken the steps to take care of that. Or a worst case scenario, we find this was an intentional violation. And so the statute has a bunch of different things the Attorney General can do. I'd say the most common is, yes, we find this was a violation. We understand this didn't happen on purpose. It was an oversight. Be sure to do better going forward. That's kind of the most common thing that they send out. They can require the board, especially if it's a second violation, to have some kind of training. They'll accept the training from town council, for example. They also have online things at the AG's office. They may tell you to create or disclose minutes if they were not properly being withheld. I don't even think this has happened more than a couple times, honestly, since this law was revised about 13, 14 years ago. They can't actually nullify an action that the board took. Or if someone was, let's say, terminated without being provided a hearing of some kind, they can require you to require the person to be rehired. Again, I just haven't seen it, but the statute does give them that authority. And if the division kind of holds a hearing, they have administrative judges who do this. If they hold a hearing because they think it was an intentional violation, this is the third complaint we got for the exact same thing this year, and you're just ignoring our advice, they can do that, and they can impose up to a $1,000 fine. Now, that does not mean with 5 members on the board, you all have to cough up $200. It's a $1,000 fine to the town, but does have to get paid in some fashion or another. Again, that's very rare, but they can find that. Again, I have never seen this. The Attorney General, if they think it's a serious enough matter, they can go to court, try to get a court order related to it. Or if 3 voters think this board has violated the open meeting law twice and they're not doing the right thing, they can actually go straight to Superior Court and file a complaint. We have seen that, not very often, but it's something to keep in mind. I won't go into these in detail. I mentioned the Natick School Committee one, and that's exactly what happened. They had an open comment, and the chair decided, didn't like what this person was saying about school staff, and shut them down. Court said, you can't do that. Free speech rights. If indeed it's an open forum and you allowed people to say what they want. Occasionally, a case has looked at the sufficiency of meeting notices, and as I say, it really varies on what the topic was. And the particular one, the court said they thought it was sufficient. We've dealt a lot with this Wayland one. There was a town manager there, and all the 5 members of the select board did an evaluation, and it has always been the case that the board has to conduct that evaluation in an open session. But the individual members wrote up their evaluations, which obviously are full of opinions, circulated it to each other, so they all knew what they could all see what the other people wanted to say. The AG said, you can't do that. There was a quorum involved, you circulated opinions, that's a violation. You either have to wait until your meeting for the members to see what the other ones wrote, or you could alternatively circulate it and put it on the website so other people see it before the meeting too. Okay. Any last ones on open meeting? Yes.
Access, physical access to the room.
Yeah.
Told a while back that door needs to be physically.
They have kind of revised that to, because you might have a case where you're in a room and the door's open and you hear a jackhammer going on or something. But if you're going to shut the door, it needs to be clear to anybody who shows up late that they can open the door and come in. A handwritten sign would do it. You just have to make sure that nobody who shows up says, oh, I guess it's not open. So that's kind of the unwritten rule now. Okay? Yes? Yeah, that is, the regulations have said there's some flexibility in how that happens. Most board members want to be able to, make corrections and whatnot. But if, for example, it gets distributed to the members, they can give the staff person any edits they want to make, gets put together, and the chair can approve it at that point. It's a little more dicey with executive session because you kind of have to decide as a board, okay, this one's done, we can release this part. That's probably better to do as a board. But yeah, that can be the case. So I will much more briefly talk about public records law, what it applies to, when you have to disclose them, and destroying them. I don't think there's a whole lot in these slides about destroying them, but in general, who oversees the public records law is the Secretary of State's office. There's a public records division with a superintendent of records. And on their website, they have this very long retention schedule for municipal records. And it's anywhere from, kind of handwritten notes that was, just to let someone in the office know that so-and-so called, those can be gotten rid of as soon as the purpose is done, right up to meeting minutes, which have to be kept forever. So the default position is if it is some sort of collection of information, written records obviously, but also recorded emails, all that kind of stuff, you should really assume that it's public and anybody who wants it can get it. There are a lot of exceptions. but you have to kind of hunt around and find one that applies before you can say, well, we do have that record, but we can't give it to you. So it looks to the content of the record, not the form that it's in. So certainly emails. It's somebody who's kind of a part-time volunteer. They're doing something at the library once a week. If they're generating any kind of record, entering something on the system or sending emails, those will be considered public record. We hate seeing these requests, but we do, that someone says, well, I want all the emails between the board members on this in their text messages. Strictly speaking, if a member of a board or a town official sent a text to somebody else about town business, if it's still around, that's a valid records request, and you have to figure out some way to print them out, screenshot or something. Including if it's on your personal phone. Again, if it depends on what the subject of this text was. Can include handwritten notes in some cases, videos, social media posts. That kind of depends on, if I'm the DPW superintendent and I'm posting on my own Facebook, certainly nothing that I post that's unrelated to the town is a public record. But if I start putting something about, this project, everyone should know about this project, that might actually, the supervisor might conclude that that's a public record and should be preserved as well. People make requests. More often than not, it's in writing, but if someone can come to the counter and say, I want a copy of such and such, as I say, it can be in writing, can be by regular mail, can be by email, fax. Those are all, it doesn't matter, those are all have to be treated as a valid records request. In recent years, the statute was amended and each town is supposed to have one or more record access officer to kind of be the central point of knowing these requests came in and are going to get answered in time. As what happens with most things, the town clerk is the default record access officer. But a lot of police departments, schools, other departments that might get a lot of these kind of requests, they'll designate their own RAO to kind of keep track of these things too. So the law says that there has to be a response within 10 days, and that's business days, not calendar days. So you don't have to count Saturdays, Sundays, and legal holidays. Some towns, particularly smaller ones, have, just for staffing reasons, they are closed every Friday. But the Secretary's office says that still is a business day, even though you may personally be closed. So a written response has to go out within the 10 business days. If it's providing all the records they asked for, you're done. If it doesn't, you need to explain why, that maybe it was just a big request, we need more time. And to the best that you can, especially on a big request, try to cite any exemptions that you think might apply to either withhold it or withhold part of it. Business days. So if you work in a department or you're on a board that got this request, stay in touch with whoever the record access officer is to kind of help you figure out where these records are. Maybe they asked the wrong department. The town is supposed to assist a requester to get it to the right place. And let's see. A response should confirm the receipt. We usually recommend even, attaching it to the email or enclosing it in the letter, just so there's no argument later about what the request actually was. And citing as best you can what's going to be withheld, explaining the reason for not having it all, and when the response can be expected. A board, a department or the RAO can say if it's a really big request or there's some other reason why it's going to take you extra time, you can yourself take an extra 15 business days, which is a total of 25, which is a long time. You can do that without getting the requester's agreement on that. Anything longer than that, you either have to get them to agree, or you can petition the superintendent of records office to grant you more time. They're pretty strict in this, so you really have to convince them why you need it. That's most of that. One thing which comes up a lot, particularly if it's a large request, it's going to take someone a lot of time to search for the records, figure out the ones that are really respond, whether they might be exempt for one reason or another. You are entitled to charge a fee for that, and that applies to the form of the record. If it's someone wants 4,000 pages of copies of paper, you can charge up to 5 cents per page. And if it's going to take a staff person a long time to put it together, you can charge the hourly rate of the lowest paid employee capable of doing the search, and that's capped at $25 an hour. Sorry. For smaller towns, I checked your population. You're a little over now, so it doesn't apply. In smaller towns, you can charge for the whole time. If you got a big request like that, you're actually not allowed to charge for the first 2 hours. But one important thing to that, again, if it is a big, complicated, and cumbersome reply, as long as you tell the person within the 10 business days, we have records, it's going to take us 6 hours to do it, so you're going to have to pay $150 for the staff time, and we don't have to start actually doing the work and putting them together unless we get your check. Every once in a while, there's a request, and we tell them they're going to have to pay $3,000. And you can always tell the person, look, it's going to take us 10 hours to do this. Maybe you're not looking for all this. If you want to try to narrow it, it'll be to both our sides' benefit. 10 business, you can take an additional 15 if you need it. If you think it's going to be more than that, within 20 days, you have to petition the supervisor of records office and explain why you need it. Oh yeah, this one is can be a little tricky. If someone comes to your counter and makes a request, that's considered the first day of the 10 business days. If you get it in writing, it's not till the next day. And so that also applies, you might get an email to your office at 10 o'clock at night on a Thursday. Well, clearly you weren't there, hopefully, anyway. And so Friday is going to be the day it was received. And so then Monday would actually be the first business day for that particular request.
So is there a statute
There isn't any statute of limitations, but that's where you kind of get into, in those 10 business days, you kind of have to, literally, what's my best guess as to how long it's going to take? You obviously, when it's electronic, it's a little easier to do a search. Well, it can be. But for that, we've got a file cabinet in the basement, and someone's going to have to go down there and dig through it. What you need to do is come up with your best estimate on how long it's going to take. Tell them we're going to charge you a fee. Or maybe you really only want the last 5 years, and that'll be a lot better, and the fee is going to be a lot less. Yeah. No, you can't say, oh, that's too old, unfortunately. The requester actually can also, if they're a reasonable one, and they are out there, they can say, okay, I understand this is going to take a long time. I'll give you an extra month. Let's see. Oh, so fees I mentioned. That can, that's good to keep in mind, but if you sent them the response saying, I'm going to charge you a fee, and that was on the 11th business day after it was received, you're not entitled to fees anymore. So that's a really important deadline to keep an eye on. There are a lot of exemptions, especially in Chapter 4 of the general laws. I'm not going to go through all of them. There are some that come up a lot more than others. The first one is a record that's specifically or by implication exempted from disclosure. Like I mentioned, the assessors, abatement applications, someone's criminal record that you may have gotten as part of a, employment application, but that you're not supposed to give that out. Domestic violence reports, student records, Commission on Discrimination documents that you may have in your file. There's a number of them. Exemption C is personnel or medical records. So if you have something and it talks about someone's medical condition, maybe they have some, some kind of ongoing physical issue, you shouldn't disclose those. Makes sense. Personnel file stuff, for the most part, if it's you sat down, let's say you're a supervisor of some office, you sit down with your employee, you talk about things they could do better, things they did well, whether they're going to raise or not. All that kind of report would be considered personnel file information, and you can withhold that. And it's the second half of that exemption is also where the privacy rights of someone outweighs the public's right to know. That's definitely a fact-specific result, but you can also do that. Deliberative process, if there's documents going back and forth between town officials trying to develop a policy position, while that's going on, you can generally say, this hasn't been finalized yet, we don't have to turn it over. Once it gets finalized, those would generally become public. Oh, so personal notes, let's say you're sitting on a board, and even though you know someone's taking minutes, you like to keep a little notebook for yourself. You don't show it to anybody, you don't make it part of the record, you just take it home, it's for your own head. That's not considered a public record. You can keep that yourself, you can say no if somebody asks for it. But as soon as you send copies around to other board members, then it's not a personal note anymore. Exception F is the investigation exception, mostly applies to the police department. Ongoing law enforcement investigations can legitimately be withheld, saying, we've got an ongoing investigation, this might prejudice us if we gave you, we're not going to tell you who the voluntary witnesses are, because then we'll stop getting voluntary witnesses. So in general, those can be withheld, or at least taken all the identifying information out. Exemption N came about shortly after 9/11, which is a long time ago now, and said, basically infrastructure records, blueprints, security measures, anything like that can be withheld if the custodian thinks it would jeopardize public safety. Cybersecurity things can be withheld. This is also the only exception where, rather than just telling the person you can't get this, you can ask them why they're asking for it. Because if they tell you, you may say, oh, maybe I don't think this is a big public safety risk, and allow them to get a copy. For any other kind of records, basically you're not allowed to ask them why. Well, what are you going to do with this? That's not part of the record, part of the law. And exemption O, personal emails and home addresses of public employees. Those can be withheld. Again, privacy concerns. Just because you might work for the town or sit on a board doesn't mean all your personal information is public. Again, appeals, similar to the open meeting law. If someone makes a request and either you say, no, those are exempt, or you only get this part, or we're going to redact the first half because there's an exemption for that. If they don't like that, they can appeal to the supervisor's office. They may contact you and look for a little more background, a little more justification as to why your answer said what it said, and they will eventually come out and say, yes, we agree, those are properly withheld, or no, you've got to turn them over within 10 days. The Attorney General, this is again, rarely happens, they can get the AG involved to go force someone to turn it over. The requester can also decide they want to go to Superior Court. Again, rarely happens. But if it does, it is kind of risky because they can go to Superior Court, sue your department about these records, and if they win, the judge can award their attorneys, make the town pay their attorney's fees. You know, again, this is in there, so it's nice to know, but it doesn't come up much. So that's the end. Anybody else with anything on public records? And if not, I thank you very much for being here again, and thanks for your attention, and hope you have a nice evening.